rules of the state of New York as to public policy. This is against public policy. Well, Cablevision stated, we did some stipulations. He stipulated that he would defend only on the jurisdiction, that the Rye Court did not have jurisdiction over Cablevision, therefore the case should be dismissed. And that he would not defend on the merits. What should Peter Lane done right there? He should have said the trial was over, because there was left no triable issues. If Cablevision was not going to dispute Glendora's evidence, then she didn't have to present evidence. Right then and there, Cablevision should have said the trial was over and Glendora wins. But instead, the trial went on 6 hours. So we have at least where a lawyer, a judge, should know the law. Well, I stipulated that I was here to get the $3,000 that the appellate court said I should have, that Lane was reversed, and the reverse of deny $3,000 is to grant $3,000. And that's what I was here for. And then Lane started doing more stipulations. I said, no more stipulations. Lane said to me, why? I said, because you did that once to me in another case and I didn't like it. I can't imagine that Lane didn't just right then and there stop the trial within the first half hour. And as you will see later, this has serious consequences. So we got two things against Lane. One, he wouldn't let me read the order from the appeals court into the record, into my opening statement. He wouldn't let me finish my opening statement. So that's two things. That's a denial of due process. And then we have Cablevision stipulating that he's going to defend only on jurisdiction, and Glendora stating that she is here only to get the $3,000 that Lane should have given her in the original action, and that he was reversed, and the reverse of deny is to grant. We have four things, right? All right. I go to the witness stand. I produce the Lane, my addendum, the hours that Dolan Cablevision had cost me, and the dollars that Dolan Cablevision had cost me by not returning my tapes. 53 videotapes of the chat with Glendora. Cablevision said he never caught it. I don't believe that. So Lane, in great solicitude, has the clerk make another copy and give it to Cablevision. And serves the paper on Cablevision. Second time, Peter Lane has served the defendant's papers for the defendants upon the plaintiff. Is that right? And so, at the end of my very long and detailed and accurate document of the hours and dollars that Dolan had cost me, Peter Lane said, I deny it. I'm sitting within 3 feet of his physiognomy. And I looked him in the eye, and I said, what is your statutory authority? He was shocked. He didn't have any. And he looked at Cablevision, hoping Cablevision would come up with an answer. What is your statutory authority? But Cablevision had no answer. Right then and there, Glendora should have won. And she's already won, the $3,000. So we break and go to lunch. And we come back. And it's another 3.5 hours, making 6 total. And Lane lets Caligari drone on about the jurisdiction when it is no longer a defense. It has vanished as a defense. What is wrong with Peter Lane? And Caligari calls the witness, Christine Savarino, who is a total flop. And Caligari asks Glendora about, do you have a contract with Charles Dolan and Cablevision that they're going to pay the costs of your public access program? That is not the issue. Glendora's not asking for the cost of producing a chat with Glendora on public access TV, Cablevision. Glendora's asking for the damages that Charles Dolan and Cablevision caused her by not returning her tapes. And Lane lets Caligari on. And I even said to Lane, would you please ask counsel what his intent is? Did Lane answer? No, this is what Lane says. He's getting to that. So he lets Caligari drone on about all of these non-issues. George McDermott was a great help. Glendora tried 3 more times to read into the record the decision of the appellate term, remanding the case and reversing it. And Lane and Caligari prohibited, precluded. This is crooked. Remember, Glendora had asked Charles Dolan to settle, and he'd refused. Remember, Glendora had presented all of her costs, hours and dollars. They were before the court. The court was wrong not to take judicial notice. Well, and all through that 6 hours, folks, neither Lane nor Caligari could come up with statutory authority for denying my ad dominant. Now, my ad dominant was only 10%. Asking 10% for what it really cost me, it cost like $50,000. And I could only $3,000 of which is reclaimable in small claims in a city court in the state of New York at that time. Nowadays is $5,000. So the 6 hours went. And they still hadn't come up with a statutory authority, so guess what Lane did? To see how he handled that. He ordered that Glendora produce a memorandum of law by March the 5th stating statutory authority. Why the court should award her $3,000. And he ordered Caligari to come up with a statutory authority. Why the court shouldn't award Glendora $3,000. He should have known the law, but he's dumping it on us. You, Peter Lane, and Rye. Now, folks, you are making believe that you are a justice of the appeals court, Supreme Court, State of New York, 9th and 10th Judicial Districts. You are making believe that you are one of the judges on this panel. You've got a judge to you. You've got 2 other judges there with you. And you're listening to plaintiff pro se, you're listening to plaintiff appellant, remand victor, second appeal, Glendora. Now, Caligari did not appear at the oral argument, but he has a good excuse. He's dead. Robert M. Caligari is dead. So George went back to Washington, D.C. Thank you, George McDermott. What a great friend. And what a great friend you were to Elena Sassower, and still are, to help her with that ravage in the District of Columbia courts. And Glendora went back to Columbia County with Florence and Dick and Megan and Linda. Now Glendora, the next day, sits down in front of you. Now reverse your role. You're no longer a judge in the Supreme Court. You're a viewer of the chat with Glendora. And I told you, a viewer of the chat with Glendora, for 2 hours what had happened in that court on the videotape. And it went to the TV stations, Cablevision and all the other ones, Time Warner and Charter. And it's 10:45 a.m. on 2 days after Valentine's Day, a Friday, and we're going to rejoice about something. We're going to rejoice that you and I are together, and we're sharing this experience, and we're being enlightened by God about it. So that was part 1 of my post-trial memorandum. Part 2 of my post-trial memorandum was I wrote 120 pages as to what happened in the court and what I thought of it. I made a record of it under penalty of perjury. And then part 3, of course, was the post-trial memorandum of law that Lane dumped onto us to find the law because he didn't know it and he couldn't find it and he didn't want to look for it. So George McDermott, great friend that he was, goes to the Library of Congress. He lives in Maryland, just outside the District of Columbia. And he looks up the law, 500 pages of it, New York Civil Practice Law and Rules, and Title 47 of the United States Code, Section 521 et sequitur, the Communications Policy Act of 1984, which tells about public access and orders public access and mandates public access. Public access is a law. That's why I can take these people to court. Public access is a law. Federal, state, and municipal. Dolan Cablevision has broken all of them. And we get it out, we mail it on, we serve it on March the 4th, just a day ahead, make sure it gets there over, I think it was overnight. Maybe it was priority, that was it. We made sure it was postmarked by March the 5th. Callaghy is silent. I never see Callaghy's memorandum of law that he is ordered to put out. Finally, on March the 16th, I make a motion to Peter Lane for default judgment. Callaghy, Dolan, Cablevision have defaulted. They have not produced the memorandum of law that would give Peter Lane statutory authority to deny me my ad damnum, my hours and dollars cost. How much was it? It was 195 hours, and it was $600 post, print, travel. And I justified to Peter Lane why I should get $300 an hour. Any lawyer can put any price he wants on an hour. You know that, don't you? In Manhattan, they put on $800. In Westchester, they put on $400. Up here, they put on $200. They can put any price they want on. I can charge anything I want for my hour. And I charge $300 on the basis of my public access expertise, which started in 1972. How many years is that? 35. On my broadcast television expertise, which started in 1952. How many years is that? About 53. That I can videotape, that I can edit, that I can put titles on it, that I can make dubs, that I know how to post them and get them to the TV stations, 53 of them. On my expertise in the courts, I've been monitoring courts since I've been in court since 1987, and I've been monitoring in court since 1990. And I've brought about 200 lawsuits, and I've watched and scrutinized the corruption and the depravity in courts for all those years. I was telling you, so it was $195 times 300. That's a lot of money, like $60,000, isn't it? And the travel and the postage and the print and all that. So I was only asking for 10%, because that was the maximum jurisdiction, monetary jurisdiction in the city court of the state of New York at that time, since it's gone up to 5,000. So, did I hear from that motion for default judgment? No. What do I get from Peter Lane? Oh, we are enclosing defendants a memorandum of law. We're making a copy of it. Lane, are you nuts? That's the third time that you served the defendant's papers on us. You're bending over backwards in your solicitude for the defendants. You're actually serving their papers for them. 3 times. Now, let's speak about what Kelly came up with. No law. He stated that he couldn't find any law that would justify paying Glendora $3,000 for her ad dominant. We had found 500 pages. Well, then Callaghan writes to Lane. He doesn't do a grown-up legal paper. He does a letter, kid stuff. He writes to Lane that, as requested, here are the copies of Title 47 of the United States Code, Section 555 and Section 5 something else of 558, and another section, 5 something, right in that range, giving statutory authority why Peter Lane should deny my ad dominant. Well, it had nothing to do with it. And they do this. This is how badly they lie and cheat. It had nothing to do with it. It didn't apply at all. It was about a cable operator not being liable for anything that a public access producer says on public access TV. This was not the issue. We weren't talking about that. That's not the case. And so with that cheat, Peter Lane ignominiously dismissed and denied and did not reverse and did not comply with the order from the appeals court. Now, you 3 judges, it comes down to that. Peter Lane defied the order of Kenneth W. Rudolph, Skelos, and Doyle. He defied the higher court. Let the trial go 6 hours for this reason. I called up. I believe he gave me a tape of the trial, but it's at a speed that we can't hear, that we can't understand. And I haven't found out to this day the technology to change that speed down to a speed where you can understand it. And guess what it would cost to do the transcription? And the appellate term insists upon the minutes. Not that they ever read it. That's a hoax. And they cost $1,300. Do I have $1,300? No. So I made a motion to Peter Lane that the Rye City Court pay the $1,300 for the minutes. He gets out of that with a cheat, saying that I didn't make a motion to renew. And you have to say that it's a motion to renew. So I do it over again. And I say this is a motion to renew. And I give him the finances. All the money that comes in, all the money that goes out and what it goes out for, because Franklin and I had kept those books ever since we were married in 1954, and I sent him all that. And he writes back, plaintiff was not specific as to assets. And so, I do it over again, and I put down the assets. And I tell him that my assets are liquid assets. Everything is going down the drain. And then he denied it. On March the 21st, I believe it was, of the year 2004, he denied paying the minutes. Well, I'd had it by then. So I appealed that decision. Oh, wait a second. Back up. When he denied it, before I appealed him, I made a motion to the appellate term to pay for the minutes, $1,300. And you denied that, Kenneth Rudolph. Or one of your people. You denied that. So you see the hoax that's gone on? They took away from me the right to appeal by making the trial so long that the cost of the minutes was so large that I couldn't pay for it, that Rye couldn't pay for it, and that the appellate term couldn't pay for it. Therefore, I couldn't appeal Lane's defiance of the appellate term. Folks, this is a rich Rye City Court. A shack in Rye goes for $600,000. You can't find a more opulent. Neighborhood than that. So that's when I appealed. I appealed his last order saying he wouldn't pay for the minutes. Now what comes? A notice from the appellate term that my brief is due on such and such a day. I think it's December 31st of the year 2004. I get it in. The appellate term says it's late, and it isn't late. The appellate term says that I served the copy on Dolan. They won't allow that. It's got to be a third party. And there's all this procedural process goes on for about a year. Finally, in 2005, George McDermott serves the appellant's brief, which is about 6 volumes. In fact, it's the 2 volumes over there that we've done in previous programs, plus this. And George McDermott serves it on the appellate term in Brooklyn. He forgets to put in the date of service, so we have to fix that up. Fortunately, Julio left it up to the judges whether they would accept it, and the judges did. Finally, in 2007, this case started in 2002, this is 5 years later, we get a postcard from the appellate term saying that oral argument has been scheduled for February the 14th. Valentine's Day. That's 2 days ago. Today is February the 16th, 2007. It's 11 o'clock, folks. What are we going to rejoice about? Sunshine on the snow? It's just beautiful. And we're not going to complain about working 4 hours yesterday shoveling. we're just going to rejoice about that beautiful white pure snow and the sunshine on it. Okay, 10 o'clock, we're moving on. What happened? I get the notice around February 1st that there's going to be an oral argument 14 days later. So as soon as I can, I finish up Glendora versus Cecilia Mastroianni in the White Plains City Court. What happened at that trial? No, I talked about the appellate decision on that case. And as soon as I get that finished and put away, and I'm holding it, I'm not serving it, until I see what happens in this case, the Rye case. And I was 32 hours reviewing 11 file jackets in a file, I kid you not, that was 11 inches thick. 32 hours I spent reviewing and writing it all out. First I got the 11 inches down to 6 inches, and then I got the 6 inches down to about 2 inches to say to the appellate term on Valentine's Day. So at 12:45 p.m. I start packing and dressing up to take the train the day before. I decided to take the train, Amtrak, from Hudson, New York to Yonkers, and the fare was $53. We had to make a special trip. My friend and neighbor Mary took me there to buy the ticket. You have to buy the ticket ahead. That Amtrak, that's no way to run a railroad. And I was ready by 2:05 when my friend and neighbor, great woman, Mary, came and picked me up and drove me to Hudson, to the railroad station. I got there an hour early, and there was this sweet, adorable Oriental girl dressed up in some kind of a pink pantsuit. I couldn't see it because it was underneath her very stylish black coat. And she told me she was going for a job interview, and I said, "You're going to get it." I said, "Nobody can compete with the way you're dressed." And so we got on the train, a lovely ride, and the person next to me ignored me entirely, didn't want to talk. That's the way they are around Manhattan, you know. They get on the train, they don't want to talk. And you're just another piece of cardboard to them. But I had a good time because I did my meditation, my creational part of the daily praying. And so I had a good time. And I fasted. I didn't eat that night again. I didn't eat that night until 7 p.m. And I got off at Yonkers, and there was my friend Patrick Hanley, who worked for Suzanne McCormick. And there was Suzanne McCormick in their sweet, cute, and that adorable. Mr. McCormick bought this car, a BMW, red convertible. And they took me to the Yonkers City Court, and I wanted to see Charles D. Wood. Charles D. Wood, what is going on down there? Small claims is supposed to be simplified, speedy litigation. In 2 weeks, you're supposed to have the decision out. We had the trial October the 25th. And here it is almost February the 25th, and you haven't got out the decision yet. What is going on in the Yonkers City Court? A judge in the state of New York, by CPLR 2219, has 60 days to make a decision. You've been about 120. October to February. Well, this sassy and unlikable and odious Gestapo that we're paying too much money for said that all the judges had left the building. Well, the storm was rumored to come at 6 o'clock. And I found out the small claims was open because people kept coming in, even in threat of the storm, for small claims. Finally, a man came in, and this odious so-called court officer said to him, "Hello, Judge. Small claims has been canceled." And I had a direct view into the face of this judge, and I could see what was going on in his mind. And he at least boiled down his anger to, why didn't they call me? So there was nothing to be seen in that court except odious so-called court officers, phony cops, and frustrated people who always wanted to be a cop and couldn't make it. And we left. And I wanted to take them to the Emerald Diner, which is right there in the corner of Bethlehem and South Broadway. It's excellent. I'm hoping that they had the same chef the other night that I was in there October 25th. But Suzanne McCormick wanted to get home because the storm was supposed to start. And she was right about that. And we went home to the affluence of her house, which is way, 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 way up a hill in Dobbs Ferry and overlooks the Hudson River. And she can see the Hudson River from the Tappan Zee Bridge almost to Manhattan. And the house is all windows. The house was built and designed by an editor of House Beautiful. Mr. McCormick bought it for Suzanne. I would say the house is like $6 million. And no, maybe more. And it was so big I got lost going from one room to another. But Patrick built a big fire in the fireplace, and I was cold. And so I sat there on the sofa next to that fire, and I wouldn't leave. And Suzanne got me the most delicious vegetarian dinner and vegetable soup. Oh. Now, we did a lot of talking. We did a lot of talking about the case of Suzanne McCormick, whose husband died in 1988 and left her $24 million. She has never seen any. Now, this is a case that I have scrutinized on television since August, and I will continue to. Something is wrong with the surrogate court in Westchester when Brewster, Emanuele, and Scarpino do not see that Suzanne McCormick get the $24 million. Who did take it? Was it Bankers Trust? I think so. Was it White and Case? I think so. Was it the other trustees? Was it Brewster, Emanuele, and Scarpino? Who stole the $24 million? And I worked with Suzanne with that 15 minutes a day, trying to solve this. If it had happened to me, I would take all those crooks to all the lawyers who have stiffed her and charged her all these fees. I would take them all to federal court on fraud and thievery and larceny. So we talked a lot about that. Then, all of a sudden, Suzanne McCormick, who was a concert pianist, when she was a little girl in Grand Rapids, Michigan, somebody took her to a concert, and she saw a piano soloist, and she said, I want to be that. And she came from a family that couldn't afford to send her to Juilliard, so she went around door to door to the rich families in Grand Rapids, and there are many, and they sponsored her education for 4 years at the Juilliard School of Music in Manhattan. She hasn't played the piano for years because of this horrible thing that has happened to her. That is a shame. And I've urged her to play for me. I wanted to hear her. She has this concert grand piano in her living room, which is huge. I'm telling you folks, that concert grand piano is as long as from my west door to this east window.